Samantha Thomas, are you on the line today?
Yes, I'm here.
Okay, welcome to you, Ms. Thomas. And Jordan Holbert, are you on the line? All right, Mr. Hobart, if you're on the line, I can't hear you. Make sure you're unmuted and state your name. I'll check the participant list. I'm thinking he's not going to be here because I think information I has from Ms. Thomas is that Mr. Hobart is incarcerated. Ms. Hobart or Ms. Thomas, is that correct?
Yes.
Okay. And this is your motion based on a default order that was entered back on May 1st. And you're asking for those default orders related to child support and other orders to be signed.
Yes.
Okay, I do have proposed orders here. Let me just retrieve those. Ms. Looney, I have in my possession here, I have findings and conclusions about a marriage, a final dissolution decree, a parenting plan, and then worksheets, child support worksheets, and then a child support order. Let me first start with the findings and conclusions, and then the final dissolution decree and parenting plan. Ms. Looney, with regard to those, do you have any input?
No, Your Honor, the state is only involved regarding child support.
Okay, so Ms. Thomas, I'll go ahead and sign off on those orders as presented. I'll take just a moment to sign those. Okay, those three orders are signed. Then now let's focus our attention on the child support. Ms. Thomas, did you provide copies of your proposed child support order and worksheets to the Division of Child Support Enforcement or the Division of Child Support?
Yes, I did. And when I talked to Cowlitz-Wakai Legal Aid, I just decided that I was going to adopt their order.
Okay. All right. Ms. Looney?
Yes, Your Honor, we did receive copies of both the proposed order and the worksheets, and Ms. Thomas did use the numbers that we presented in our proposed worksheet when we entered our notice of appearance. I have reviewed her proposed order, and it is accurate according to the worksheets, so we are in agreement with having that order entered today.
Okay, very good. I'll go ahead and sign off on the worksheets and the child support order. And just confirming the child support order, it's setting the transfer payment at $50 for Mr. Hobart.
That would be correct according to the statute, Your Honor.
Okay, great. All right, I've signed off on each of those orders. Ms. Thomas, do you have any questions?
No, is this just that because I want my divorce, so is this the end of it, or? Yeah,
that's a great question. So we have a final divorce order or a dissolution decree. So yeah, this marks the end of the divorce is finalized at this point. You have parenting plan in place. You have a child support order in place. So at this point, it's complete.
Okay, and then do I just go to the clerk and get the paperwork of the dissolution of marriage?
Mm-hmm. Yeah, you could stop by the clerk's office and obtain copies, maybe 2-3 days.
Okay, thank you.
Very good. Ms. Looney, any final items?
Nothing further, Your Honor. Thank you.
Okay, great. Thank you. We should have, and we do. We have Ms. Holders present representing Ms. Rhodes. We have Mr. Jensen present, and we have Mr. Lawrence present. We're on today for presentation. Didn't receive any proposed orders, so we'll hear from Ms. Holder.
Yes, Your Honor. My apologies for not getting anything in front of the court for it to review and sign. The parties had been working to get the orders that we are supposed to be here to be presenting. And I just became aware while we were working on our child support that there has been a circumstance change between the parties. It seems that something has changed with Ms. Rhodes' insurance. And then the numbers that we were working off for Mr. Jensen, we had numbers from 2022. And so in fairness to both the parties, to keep us from coming back in the future time and time again to adjust everything, we just wanted to allow some extra time so that Mr. Jensen and my office could work to get some accurate numbers. And if we can't, we'd like to come back in 2 weeks. That'll allow enough time for us to go back and forth to come to an agreement, but it'll also allow both parties to have time to get documents in front of the court for the court to have an accurate representation of what both parties are requesting.
Okay, thank you, Ms. Holder. And so in addition to the child support, then we would also be looking for a parenting plan?
Possibly, with the change of insurance,
Hey, do you still have a balloon blower ever?
Ms. Chapman?
No,
Ms.
it's
Chapman?
all out. It's my turn.
Ms. Chapman, can you mute your phone, please? Go ahead, Ms. Holder.
I don't believe it's going to change the parenting plan that we had already gone to court over, but there is a possibility that with a change of insurance, there could be a potential change of job, more job hours. It could potentially change that Section 8 and 9 schedule. And so I just want to be 100% sure that it's not going to change it before we get something in place and then have to come back and modify it again in the future. So out of an abundance of caution, we just want to allow a little bit of extra time, but I don't think it's going to change anything.
Okay, thank you. Mr. Jensen?
Yeah, me and Amanda talked previously to this. We agreed that 2 weeks is fine.
Thank you. Mr. Lawrence?
I have no objection, Your Honor.
Okay. Yeah, that sounds fine, what you've discussed as far as the proposal and discussing child support and the like. So let's set it over to 2 weeks. So that'll be on the 16th of October, Wednesday, 9 o'clock in the morning. We'll set up for that date for presentation.
Okay.
Thank you so much, Your Honor.
I could call you right now, Amanda, or what?
Go ahead and give my office a call.
All right, thank you.
Perfect. Great.
Thank you, Your Honor.
We have
Thank
Mr.
you.
Johnson in the courtroom with us. Welcome to you, sir. And then Shannon Johnson, are you on the line today?
Yes, sir.
Okay, welcome to you. This is Mr. Johnson's motion for appointment of a guardian ad litem. Looks like there was personal service was effectuated. And Ms. Johnson, did you receive a copy of Mr. Johnson's motion?
Yeah, he wants the guardian ad litem.
All right, very good. And do you have any opposition to the motion proposed by Mr. Johnson?
Not really. I already applied for one at the very beginning of the case, and they appointed a court investigator. So I don't know that we need a guardian ad litem right now because nothing has changed. But I'm not opposed to it if the courts think it's a good idea.
Okay, thank you. Mr. Johnson, I am assuming that you're still wanting the appointment of the guardian ad litem?
Yes.
Okay. All right. I'm fine with the appointment of a guardian ad litem. The court did appoint a family court investigator to give kind of a quick turnaround time, just to give the court a view of what's going on. But I think there could be additional in-depth conversations and investigation by the guardian ad litem that I think would be helpful. So I'll sign off on the order. So we have the way we work the guardian ad litem rotation is we have the next 3 individuals who kind of, as each person is appointed, then another person comes up into the list. And so I'm going to ask the clerk to tell us what the names of the 3 individuals are, and then each of you would have an opportunity to strike one of those individuals. If nobody's stricken, or if only one's stricken, it's whoever's at the top that remains.
The next 3 are Sherry Evald, Karen Lawrence, and Amy Turnbull.
I'll turn first to Mr. Johnson. Would you like to exercise a strike on any of those individuals?
No.
Okay. And Ms. Johnson, would you like to exercise a strike on any of those individuals?
No.
Okay. I'll appoint Sherry Evald. I'll go ahead and just write her name in here. Madam Clerk, she spells her name S-H-A-R-I, correct? E-R. Okay. Thank you. I am appointing the guardian ad litem at county expense, so neither party will have to expend funds for that. Generally, we like to set 3 dates. One is to make sure kind of a early check-in to make sure everybody's communicated with guardian ad litem and they've received, guardian ad litem has received contact from each of you. So generally that's set at 30 days. So looking at the calendar, I'm going to set that just for a review on November 6th, and that'll just be a check-in to make sure that everybody's communicated and the process is moving forward. Then generally we set it out roughly 4 months. So I would set a review, and this will be at a different date and time. Actually, the November date will be a different time too, since we're shifting a little bit. So
Yeah, what time is that, sir? Sorry.
yeah, let me get the dates down, then I'll share that with you. Okay, so what I'm looking at 2 dates. One will be the first initial review to make sure everybody's on the same page and we've communicated contact information. November 4th at 9 a.m. Pardon me, 1 p.m. We're shifting docket. So this docket, as of November 1, will be moving to Mondays at 1 p.m. So that'll be November 4th, Monday at 1 p.m. And then we'll have the final report due on February 3rd, Monday at 1 o'clock. So that's when that report would be reviewed. So we'll set those 2 dates. I'll ask Mr. Johnson if you have any questions or concerns based on the court's order.
No, that'll work.
Okay, all right. Ms. Johnson, any questions or concerns?
No, sir.
All right, that order is signed, and that'll conclude the business for today. Any further items, Ms. Johnson?
No.
Okay, Ms. Johnson, any further items?
No, thank you.
Great, thank you.
Have a great day.
All right. Looks like Ms. Sessler's present. Feel free to take a seat there, Ms. Sessler, and just make sure that your mouth is relatively close to that black microphone, as that'll capture your voice for recording purposes.
Thank you, Your Honor.
Welcome to you. And then I'll ask if David Groover is present. David Groover. All right, Mr. Groover, if you're on the line, please make sure you're unmuted and please state your name. All right, I'm not hearing any response from Mr. Groover. Let me touch base with Ms. Sessler. And am I pronouncing your last name correctly?
You are, sir.
Okay. Ms. Sessler, this is your motion for related to title to some real property. And I'm just curious, did you send a copy of your motion and accompanying documents to Mr. Groover?
We've tried to communicate with him at his last known address and things keep coming back. We have no way of contacting him. That's why I'm trying to get to the court.
Gotcha. Okay. Yeah. So that's one thing I always look for in any type of motion is that you have a desired end, you want something, and then we always look to make sure the other party has notice of that and then they have an opportunity to respond. So as you said, at this point, you haven't been able to find him. So that's why I'll look for what's called a declaration or affidavit of service in the file to make sure that's where somebody on your side, like a friend or family member, would serve him with the documents, and they would fill out a document and say, hey, on such and such a date, I gave these documents to Mr. Groover, and here's a listing of the documents. So that document's not in the file. That means we can't move forward today with the motion. So there's some options that you have. So since that's a critical piece to the equation, that there has to be service. And if you don't know where the person is, then you can make a motion to the court for service by an alternative means. So the normal means of serving somebody is you go knock on their door, hand them some papers. Another option is that you could mail them to an address if you know that they live there, and there's no, you don't get it sent back to you. So if you don't know that information, where they're currently located and the like, there's a form that you can fill out and submit it to the court to serve somebody through an alternative means, whether it's a last known address or through publication in a newspaper. There's several different options. So you can find those documents. There's two sources where you can find them. One is called WashingtonLawHelp.org, that website. Look under the dissolution or divorce section and look for motion for alternative service. On the Washington State Courts website, you can look under their forms section. So if you just type courts.wa.gov and then search under the forms section, you should be able to find a document related to a motion for alternative means of service. So then you'd submit that motion to the court and then ask for whatever relief you're asking for, whatever means of service you want to serve the person. And that'll be pretty clear when you're filling out the form. And if it's approved, then once that's been approved, then you would go ahead and serve in the manner that the court allows you to serve. So whether that's by email or through some other means. So that's kind of the lay of the land. Questions on that?
Yes, Your Honor. And were you able to read the letter that I submitted with my motion?
Did you say, did I read your letter?
Yes.
Yeah, I read your motion that you're talking about the half share of the 250. The order said that it needed to be, you get half of it at the sell or refinance, and he hasn't refinanced it and hasn't put it up for sale. There's
been no communication and he did not support my son. So I'm trying to figure out the best way to do this. Is there any way that I could have the right to sell? Because I can no longer maintain the property physically or financially.
So for there to be a proper court order, there needs to be notice and opportunity to respond by the other side. So that's why I'm saying that motion to serve by alternative means is a critical step. So that's the first step that you need to explore. And then once there's been service, if he chooses to respond, great, we'll have the hearing. If he chooses not to respond, but you've served him, then the court can grant whatever relief is appropriate.
May I find out what relief may be appropriate so I know what to expect? Because I did not expect this.
Well, so judges as a general rule are not in the practice of giving prospective or future rulings of what may occur. Certainly a party who feels that they have a legal right to something can make their argument, and then the court can rule on that. So
I'm not exactly certain what my next steps are other than to do these things. And do I get another court date? Do I get paperwork to say what you said?
Sure. And that's why I made reference to those two different websites, the WashingtonLawHelp.org,
okay, to
find that motion for alternative service. And then the other source where you can find that similar document that you can fill out is the Washington State Courts form database. So it's courts.wa.gov, and then just look for forms. That's where you'll find a motion that you would fill out. You'd submit it to the court, asking for whatever relief that you feel would be give him notice of the hearing. And there'll be some explanatory documents there on that same webpage that will give you a little more detail and context. And then you'd submit it. If it's approved, then you'd go ahead and serve the other person by the means that the court allows. And then you would, after having served the person, then you would note it up for a motion docket, such as you did today, and then we'd hear the case.
So I pretty much have to serve him and then start over with what I just did?
Yeah, and the basis of that is just that constitutional protection of notice and opportunity to be heard. So if we were to move forward today, I recognize there's an order in place from way back when, but he hasn't had an opportunity to know what's going on, nor an opportunity to respond. If you serve him and he chooses not to respond, then we just move forward without his input, but he has to have notice and an opportunity to respond.
Okay. And can I have paperwork in my hand to confirm what you've just said to me?
So a couple of different ways that you could approach that. One, you could ask for a copy of the clerk's minutes. That may provide some detail. They tend to be fairly generalized. The other option is you could get a copy of a DVD of today's proceedings and get a recording. That'll cost $25. You can check with the court administrator and get a copy. Or you can rely upon going to washingtonlawhelp.org or the Washington State Court's webpage and look for forms. Alternative service. Okay. All right. Thank you. The cause number. Looks like Ms. Malave is coming forward. She's here in the courtroom. I'll ask if Jorge Aguayo is present. All right, Mr. Jorge Aguayo, if you're on the line, if you'll make sure you're unmuted and state your name, please. Okay, I'm not hearing a response from Mr. Aguayo. Ms. Malave, have you heard any communication from Mr. Mr. Aguayo, whether he's coming today or not?
No.
Okay, so we were here last on the 25th of September, and we set it over to today's date. Okay. So this is your motion, Ms. Malave, related to a parenting plan and a restraining order. Mr. Aguayo submitted a contrary parenting plan for what he felt would be in the best interest of the child, and I've reviewed yours. And let me just take a quick look here. And this is pertaining to your 5-year-old daughter,
Yes.
correct? Okay. All right. When I looked at that and I read the different orders, and I'm not sure where Mr. Aguayo is here, why he's not here. He was here at the last hearing on the 25th, and we clearly set it for today at 9 o'clock. And as a general rule, I clarify with both parties that they'll be able to be present. And I think I did that at the last hearing, and we confirmed that.
He did tell me that there was court on Wednesday, so he was aware.
Okay. Yeah, and he was here present on the day we set the hearing. And let me just double check to see if sometimes people will send a message through the chat function if they're having difficulties with their Zoom or they can't be heard or their microphone's out. Not seeing anything there. And again, I'll just ask if Jorge Aguayo is on the line. Looking under J's, under Jorge on the participant list, not seeing anybody. And then I'm looking under Aguayo, not seeing anything there either. I want to give you a voice, Ms. Malave, if you would like. I think I have my decision. I think I'm going to adopt the proposed parenting plan that you've suggested. But do you have any comments you want me to hear before I make my decision?
He's not here to argue his side.
Mm-hmm.
I'm not fully against letting him see her, but once he can prove that he's sober, then we could revisit, I guess.
Sure. And then that's an important consideration. You know, the parenting plan orders, people deviate from them regularly. But if there's ever a conflict, then the parenting plan controls. And so that provides flexibility for families because families need flexibility. So if you feel it's appropriate, then you two can do whatever you'd like. But if there's ever a conflict, then the parenting plan controls and everybody needs to follow that. So your request was to be the primary custodian and have sole decision-making related to non-emergent healthcare and education issues, and that you're also asking for what we call 191 factors. That's a reference to an RCW related to emotional and physical abuse and substance use disorder issues. So I'm fine with that. And then at this point, you're requesting no visitation. Is that correct?
He's had some because of the other court order that was in place.
Yeah, where you were able to agree to.
I've been letting him see her on Saturdays for some odd hours, but not overnight.
Okay. Do you, as far as your proposed order, are you wanting to amend that order to include that, or do you want to just keep it as proposed?
Oh, I would amend it.
Okay. So when you say amend it, meaning allowing carving out some specific time for Mr. Aguayo to have parenting time with his child?
Yes.
And you-
Sorry, I just got off of work for 12-hour shifts. So.
No, it's quite all right. It's quite all right that I've worked graveyard shifts before, so I know that foggy feeling. So Saturdays, what was the time that you had been using, or
10 a.m. to 7 p.m. Depending on her soccer schedule.
Okay. So if there was a soccer match, then it might start at noon because the match was at 10 or something.
Yes.
Okay. And then, Ms. Malavi, did you submit a proposed parenting plan order?
But,
So sometimes people, when they come to court, if they're asking for a parenting plan, they will propose one and say, hey, if everything goes my way, this is the way I want the parenting plan to
no, I
read.
didn't.
Okay.
I wasn't sure if I was supposed to.
Yeah, and that's quite all right. Let me just take a quick moment to pull up that website that I mentioned to the prior litigant about the forms. So let me just see if I can find that order, and I'll just take care of it now. Hey, Mr. Aguayo. So, Mr. Aguayo, I just called your case just a moment ago. I was talking to Ms. Malave about it, and I was granting her requests for parenting plan since you weren't here and we hadn't heard from you. So now that you're here, we'll pause that. We'll hold the hearing now. So this is on Ms. Malave's motion for a temporary parenting plan. I reviewed your temporary parenting plan. And just so you know what I heard from Ms. Malave before you came in, she had indicated that the past couple of weeks that you'd been following Judge Basher's order where you two could agree to some visitation. And she had indicated that you'd had visitation or residential time with your daughter on Saturdays, roughly from 10 a.m. to 7 p.m., with exception for like soccer matches or what have you. So if she has a match at 10, then maybe the visit wouldn't start until noon or something like that. So, so that was Ms. Malave's. That's what she shared with me, and she shared that she just wanted to make sure that you're doing well as far as like alcohol or substance use, that you're doing fine with that. So that's kind of a little bit of what we talked about. So I think we'll just kind of start fresh, kind of that. You heard what I heard from Ms. Malave before. So I'll hear from Ms. Malave as to her reasons why her parenting plan should be adopted, and then I'll hear your reasons for why your parenting plan should be adopted.
So I just repeat what I already said too, right?
Please.
Okay. I'm not against him seeing her. I just want him to know that he's clean and sober before he can have her overnight. And
what do you think as far as what would be the proof that he's clean and sober before overnights occur? How would that be determined?
I would request a hair follicle test.
Okay. Okay. And then you were suggesting then a residential time every Saturday, 10 a.m. to 7 p.m. with some flexibility for soccer.
Yes.
Okay. And then as far as the restraining order, as it stands now, the restraining order say that Mr. Aguayo is not to have any contact with you or Medalia.
The restraining order was lifted 3 weeks ago.
2 weeks ago.
The
Okay.
second court date we had, the other judge lifted it.
Perfect. Okay. Thanks for that clarification. Anything else, Ms. Malave?
No.
Mr. Aguayo, glad you're here. What's your viewpoint on your parenting plan? Why?
I'm not against anything. Let's shoot once. I'll do whatever to prove that I'm doing good to see my daughter. You know what I mean? I'm not opposed to anything. As long as I can see my daughter and everything goes back to how it was for the most part, you know? As long as we come to an agreement and communication, it's fine. And
where are you kind of with there's been concerns related to alcohol and the like. Are you doing any treatment with that? Are you going to self-help meetings, AA, anything like that?
No,
Okay.
but I haven't looked to get into it though. On my own, yes.
Okay.
Yeah.
So you've looked into that? Have you had any assessments or evaluations? Okay. Do you think that would be important for you to do?
Again, I'm not opposed to it. I was going to make sure that my daughter's good, to make sure that she knows that my daughter's good while she's with me.
Okay. All right. Okay. And then in your proposed parenting plan, Mr. Aguayo, you had indicated that your request was your residential time would be Friday at 4 p.m. or after school until Monday start of school, and you just drop her off at school.
That's with everything, what you come to an agreement about her being able to connect with whatnot,
Okay. So for the time being, it sounds like are you comfortable with the Saturday visits until Ms. Malave is comfortable with that expansion, or that you're maybe get an evaluation that says you do treatment and they show that you're compliant with treatment, and then there could be a change there? Or Ms. Malave, what do you think about that?
That works for me.
Will we be able to add another day in between, a couple hours, just, instead of not just Saturday?
Like a midweek?
Like, somewhere during the week, maybe a Wednesday or something, just for a couple hours during the day, then give her back and forth, back time, obviously a couple hours. Have dinner with mom.
Ms. Malave, do you have any input on that?
No, we could do Wednesday since it's early release, so she would have more time. after school.
What time does she get out on
2
Wednesdays?
o'clock on Wednesdays.
2 o'clock. And so you're proposing that Mr. Aguayo could pick up your daughter at school being released and then return maybe at 6, or I don't know what's your thought?
That could work, yeah.
After what time are you done with work?
Oh, if I work on Wednesday. We could do 6 just to be safe.
Okay. Mr. Aguayo, what are your thoughts? Like say 2 to or after school or 2 p.m. until 6 p.m.
Yeah, I'm not on her school information, so I can't pick her up from school, so I'd have to meet with her unless she puts me on, but I'm sure she doesn't want to do that, so I'll just clear up.
Okay, so the exchange would be at your house.
We've been meeting at the courthouse, actually.
Okay.
Yeah, that's fine.
Okay, so exchanges at the courthouse. Okay. And when you say courthouse, this courthouse. Okay. All right. So let me let me just go through this with the parties. I have the parenting plan here in front of me, so I'm just going to type it as we go, and I'll share the information as I go along, so you're aware of what I'm typing. So, and then if you have any questions, don't hesitate to let me know. So I just typed in child's last name is, and then she's age 5, and there is a request from Ms. Malave related to. Let me just pull it up here. For it's what we call a 191 factor. The 191 is a reference to a revised Code of Washington, a statute or a law that puts some limitations, saying, hey, there's some issues that need to be worked through with a particular parent, and she is requesting the substance use disorder that be included therein. Do you have any concerns if that's included? Okay, so I'll include that. I'll just put that in there. Jorge, and you go by Aguayo Jr., correct?
Correct.
Okay. Okay, so with that 191 factor being present, the substance use disorder. So I checked a bark. It says the following limits apply to Jorge Aguayo, and it's the parenting time schedule that we've talked about, which would be the Saturday and then the Wednesday. And then it goes on. Then I'm going to include here that an evaluation occur for Mr. Aguayo related to any substance use disorder issues. And if they come back and say that there's no issues, there's no issues. If it comes back and says, hey, we want you to engage in outpatient treatment 2 days a week and go to self-help meetings, then you just follow through and comply with that. And I think that's important also just with parents. I mean, if parents can be healthy and well, that's going to do nothing but help their child be healthy and well too. So.
I have a question.
Go ahead.
Would we have another court date or a follow-up date?
We can. We can. What would be the purpose?
Well, I'm just wondering before we do overnights, because I did think of another concern. Sorry, my brain is not.
No, it's okay. I mean, there's nothing wrong with having a review to see how things are going. Mr. Aguayo may be doing fantastic, or he may be struggling. He may be, we don't know. Humans, we're kind of like this sometimes. So, Yeah, so we can include that. So then I put in here that Mr. Aguayo would get that substance use disorder evaluation. And then you'd need to provide a copy of the evaluation to Ms. Malave and also file one with the court. And then if it requires treatment, then you would just follow through with that and do what's required. And then there's a section here that says if you don't follow through with the evaluation or the treatment requirements, it says what happens then. So sometimes, generally, it's kind of a big stick, if you will, that if a parent is ordered to do that, and then if they don't, often the consequence would be that there's reduced visitation or no visitation. So the strong encouragement is to just do the evaluation. If it does require treatment, then you just do the treatment. Any thoughts on that? Okay.
Actually, I have a question. Is there any time frame that I have to get that evaluation then?
Yeah, it's a good question. There's specific, I think we need to set specific dates. At least for me, I work better if I have deadlines.
No.
Yeah. Yeah. Right. I think you can get an evaluation fairly quickly. Then getting the assessment back takes a little bit longer. I would say, have the evaluation done within 6 weeks.
Okay.
So today being the 2nd, we would have that done no later than November 20th. So I'll just put that in here so everybody knows what the deadline is. Okay, so if the consequence, if the evaluation is not completed or the treatment recommendations are not followed, then I'm going to put in residential time will be suspended until it's reviewed with the court. So that means if you don't follow through with the evaluation, if you don't do it by the cutoff, then the residential time would stop until we come back to court to review and say, well, what's going on? And if the evaluation says do treatment and you're doing the treatment, but then you stop doing the treatment, then the visits would stop, and then we'd have to come back to court and kind of re-gauge where we're at. But I assume that's not going to happen. I assume that you would follow through with anything that's required. Okay.
And as long as I'm doing the treatment, as long as I'm doing the treatment, and if I have to go that far, I can still see my daughter, right? As long as I'm still going.
Mhm.
Okay.
Yep.
Sorry.
I have a question/concern.
Go ahead.
I've had Saturdays off, but this Saturday I work.
Mhm.
Would it be possible to have my sisters meet with him and pick her up on Saturdays?
Yeah, I think, there's no requirement that a certain parent do the drop off. If a parent, life gets busy, sometimes we rely upon our tribe, if you will, our family members to help us out. So, yeah, that's fine. The decision making that Ms. Malave, you were asking for sole decision making, and Mr. Aguayo was asking for joint decision making on school and education and non-emergency healthcare. Do you still feel that way? Do you want to do that? What's your position related to that?
I don't want to sound like a broken record, but if he can prove that he's good, then we can do joint decision making,
Okay. And when you say good,
like the eval and stuff like that.
okay, Mr. Aguayo, your thoughts on decision making, whether it's joint or only given to one parent? Okay. So it's a temporary parenting plan. So that means that if there needs to be adjustments, there can be adjustments, and it's in place until there's a trial or there's an agreement for a final parenting plan. So I'll include it as joint decision making at this point. I'm going to say here for dispute resolution that the parties will go to court. And then I'm listing the primary custodian as Alyssa May Malave. And right now, your daughter, she's in kindergarten?
Yes.
Okay, so she's school age, okay. I appreciate you letting me take the time just to go through this. It's a pretty in-depth document, and I think it'll save time in the long run. And the pickup time on Wednesday with the early release, if the exchange occurs at the Hall of Justice at 2 p.m., does that work out, or is that too soon from the release time of getting out of school and transporting?
2:20, depending on traffic. She gets out exactly at 2.
Okay. Just to allow a little flexibility, any concerns if we make it 2:30?
That's fine.
Okay. Are you okay with that?
Mhm.
All right, so we'll say 2:30.
Yeah, but that way she doesn't have to worry about being late or anything like that, or rush or anything like that.
Right? Yeah, allows a little more flexibility.
Yeah.
I'm saying that the summer schedule is going to be the same as the school schedule. That'll just basically follow the Saturday, Wednesday. That'll be at least on a temporary basis. And then as far as the holiday schedule, I'll just say it's the same as the school schedule and the summer schedule. And if the parties want to work out details related to that, you know, and if there's any specific concerns related to holidays, I know for a lot of people, Thanksgiving and Christmas are big holidays. Those are important to a lot of people. Do you feel that do you need the court to order what that schedule will be, or do you feel that the parties could work that out, Ms. Malave?
We could probably work it out.
We've been able to.
Okay. Okay. All right. So I won't order anything there. And then as far as transportation, exchanged at the Hall of Justice in Kelso. I'll say both parties or their designees or people that you ask to do the drop-off. And I'm also going to include that all persons transporting your child must be properly licensed and insured drivers.
Okay.
There's a section here about moving with the children or relocation. Has a really important information, gives a lot of detail in there. So make sure you read over that
Okay.
and are familiar with it. Okay, so I'm going to go ahead and print that now, and then I'll bring a copy into both of you.
Okay.
So bear with me just one moment.
Thank you.
All right, so just those are just copies, and I've got the original. All right, go ahead and take a seat, and then we just go over that. So you'll see on page 1 that it's a temporary order. It includes your daughter's name, her age. Under paragraph 3B, you'll see the substance abuse issue, that finding. And then under paragraph 4, that there'll be a limited contact as shown by the parenting plan, which is in sections 8 through 11. On the bottom of page 3, under paragraph 4, it says evaluation or treatment required for Mr. Aguayo, be evaluated for substance use disorder, start and comply with treatment as recommended by the evaluation. And that evaluation has to be completed by November 20th of this year. Joint decision-making on non-emergent healthcare, school and educational pursuits. Number 6, dispute resolution. On page 5, it says go to court. Bottom of or top of page 6 is the custodian is Ms. Malave. And then paragraph 8 says that the 8B at the bottom of the page, the school schedule starts immediately. And that'll be every weekend from Saturday at 10 a.m. to Saturday. Oh, I put 10 a.m. on my copy, sorry. 10 a.m. should be 7 p.m., so I'll fix that. And then Wednesdays at 2:30 to Wednesday at 6 p.m. Schools under paragraph 9, the summer schedule, same as the school schedule. Paragraph 10, the holiday schedule is the same as the school schedule. Paragraph 12, the transportation or exchange will occur at the Hall of Justice. And that's where it says both parties or their designees to meet at the Hall of Justice. All persons transporting must be properly licensed and insured drivers. Then paragraph 13, that's where I talked about the relocation or moving. Read that, please. If that applies, there's some specific timeframes you need to follow, both for requesting and objecting. And then paragraph 15 on page 13 says this is a court order. Paragraph 16, it says it's a court order, and then there's a place for a signature. Any questions about that, Ms. Malave? Mr. Aguayo? Okay, so go ahead and take those copies. The one change that I made is the time on Saturday. I accidentally wrote 10 a.m. to 10 a.m., 10 a.m. to 7 p.m. So that's the only change that I made. So I've signed off on that. So I think that takes care of things for today. Okay. All right, thanks. Geis. Okay, very good. Thank you. Ms. Geis is in the courtroom. I'll ask if Jacob Geis is on the phone call.
Yes, sir.
All right, I see you, Mr. Geis. Welcome to you. All right, here we're on, it looks like this is related to calculation of a purge amount related to the contempt that was found by Judge Basher related to the truck payments.
There's the truck and the back child support.
Okay. So, right, because Mr. Geis provided some pay stubs from the post office where it shows some, I think it showed some withholding for child support. Did you see those documents?
I did see the documents. I had to buy copies from the clerk.
Okay. All right. So just let's take a quick look at this and I'll hear input from both parties, please. As far as the truck, initially it showed the amount owing was $3,952. And I had a record that Mr. Geis had made 4 payments. And then we were looking at the remaining amount, and that would be the amount that would purge the contempt.
So on the truck,
Well, I'm not sure if it's, I didn't put on my notes. Oh, no. There's an outstanding balance of 10,342 initially, and then that's when it was repossessed, right?
yes.
And then Mr. Geis needed to refinance the truck by a date certain.
And he never did.
Okay.
And so my name's still attached to it at the bank.
Okay.
I've made 2 payments now. He won't communicate with me about making those payments or reimbursing me.
Okay.
It's $100 a month. He's never been in contact with the bank.
Okay. So you're asking then for Mr. Geis to refinance the truck, the deficiency by
So
a date
they
certain.
won't refinance the truck for him at Red Canoe. He'd have to get a loan through a different bank
Okay.
to take over that.
Okay.
I'm just asking him to make the payments.
The $100 a month?
Yeah.
Okay.
There's a $10,000 balance on it and he's not even communicating with me about it at all.
Okay. Mr. Geis, what's your position related to that?
I have communicated with the bank about it, and I told them that I'm not in any financial disposition to be able to do anything at the time, and they told me that when I was available to be able to do something about it, that I could set up payment arrangements then. But they weren't going to set anything up until I had the means to be able to follow a payment plan.
So Ms. Geis is requesting that you pay the $100 a month payment. Is that something that you can do?
I cannot currently afford that. I can't even currently afford to financially sustain myself.
Okay. So there's a couple ways to approach this. So the contempt was found related to the non-payment. Judge Basher made that finding. And at this point, the order was that the truck needed to be refinanced or make payments on it. So I'm not sure which of those you want to do, Mr. Geis.
I attempted to refinance, and upon me trying to refinance, they also addressed that I needed a cosigner based off of my current credit. And I don't have a cosigner that could co-sign with me. And so payment arrangements was the option. And I did communicate with the bank about payment arrangements. And they told me that if I didn't have the means to be able to set something up today, that they weren't going to worry about it. And this is when I talked to them.
That they weren't going to what?
That they weren't going to start a process.
Because I was the one that took it upon myself to charge off the account. So when it gets sent to third-party collections and I'm making the payment, so they stopped reaching out to him.
So Mr. Geis, it seems based on the contempt and the, how we got to this point, that deficiency is your responsibility. So there's 2 ways to do it. Well, one, I can say that you have to refinance by a date certain, or that you take over the payments on a monthly basis.
I can understand that I would take over the payments, but I'm not currently in any disposition to be able to afford to do that. I can't afford to add anything to my plate because I already don't have anything on my plate to give. So I'm not sure exactly how to go about this better. I understand the refinancing and accepting responsibility for the truck. What I'm telling you is that I'm not arguing that. I'm just saying that I don't have any ability to do anything more than what I'm currently doing. I'm not even, go ahead, apologies.
Well, just my apologies for interrupting. Have you checked with other financial institutions other than Red Canoe, credit unions, banks? Have you checked with other finance companies? They generally charge a higher interest rate. Have you checked with them?
So I did talk to one main financial. I did talk to Credit One and other companies, and they were telling me that the loan amount, unless they have collateral, they're not willing to take on the loan without anything collateral wise.
Okay. All right. So I think what needs to happen here, when is the $100 a month payment due each day? Or each month?
It's just due by the end of the month and I've already made 2 payments.
Okay. So you've paid for September.
August and September.
August and September. So the next payment would be due October 31.
Yes.
Okay.
And I normally use my second paycheck of the month to just pay it and get it over with if he hasn't reached out to me.
Okay. What we're going to do is that I'm going to require Mr. Geis to make that payment by the end of each month, and we'll have a review the following Monday each month to make sure that that's been paid. So we'll set a next court hearing. That'll be on November 4th at 1 p.m. We're changing this normal Wednesday at 9 a.m. docket. As of November 1st, it's changing. It'll be Mondays at 1 p.m. So we will set it for the first Monday of every month to make sure that that payment is made. So the first review hearing will be on November 4th at 1 p.m. The second will be on December 2nd at 1 p.m. and so on. January 6th at 1 p.m., February 3rd, 1 p.m. And if you make that payment, Mr. Geis, prior to the review date, that you wouldn't and provide proof to Ms. Geis or the court or both, then you wouldn't need to be here. If you have not made the payment, then you would need to be here to explain why, and we would discuss potential ramifications or consequences for non-payment.
I understand the perspective of the ruling, and I want to just elaborate one more time that I'm not currently in any financial disposition to be able to afford $100 a month additional on top of what my current outgoing is. Based off of my pay stubs as seen, you can see that I only make at maximum probably $1,200 a month. This last paycheck in a 2-week period, I got to $340 after child support was paid. That was what my take home was. My rent is $800 a month, and there is other additional expenses, food, electricity, and so on. And so for me, on a $1,200 a month basis, I can't afford $100. I can barely get by as it is. I'm doing the best that I can and going to food banks just to be able to survive at the moment.
Have you taken a second job?
I can't take a second job with my current employment situation because with the post office, I'm more or less on call basis, and I don't have a vehicle at the time. I had to turn in my truck, and so I've looked into possibly getting another job in the evenings after I would be working at the post office, but I don't have means of transportation at the moment. I would be more than grateful to be able to do that.
Your Honor, I'd like to state that he has a girlfriend that lets him have access to her vehicle, and I'm pretty sure she's living with him. So, I mean, that should be someone at least helping him with his house bills.
Okay. I'm just writing a bench order, one moment. So from what it sounds like, Mr. Geis is an able-bodied individual that has the ability to work a second job. And just for an example, I have friends who are fairly low income. They both have regular jobs and they both took on separate jobs and they work in the evenings. And so they're working about 16 hours a day to make ends meet and because they had some new expenses that they had to cover. They're weary, they're tired, but they're making it happen. Mr. Geis will need to step up to the plate and pay the $100 per month. So the first payment is due no later than October 31st. You'll need to provide proof of payment to both Ms. Geis and to the court. We will review that on November 4th at 1 o'clock in the afternoon to make sure that payment has been made. And then we'll review that on the first Monday of each month at 1 p.m. to make sure that $100 payment has been made. If the payment has not been made, then the court does retain contempt powers. So just be advised. So I've signed that order. Then the next item to address is the child support. Mr. Geis, you submitted some pay stubs, and I want to ask you about those because I wasn't quite sure how to read those. They're not the most self-explanatory documents. In the first paycheck, I showed, it looks like it said CS, and there's 2 lines that have CS on it, which I'm assuming is child support, and you can help me clarify if that's incorrect. The first one showed $362, and then another withholding of $233. And that's in reference to the pay period number 1624. So it shows CS/SS, and it shows, is that $362.40? Is that child support that's withheld?
That's one portion of child support, and then I have another child support case, and $133.94 is going to the other child support case.
Okay, so the 362 pertains to this case.
Yes, sir.
Okay, and then looking at pay period number 17, $414, that there's a payment there that's going out in this case. And then I see 2 other statements, the pay period 18 and 19, where it's respectively $432 and $461. What are those pay periods? What are the date ranges for those? I didn't see that.
The date ranges.
So for example,
I get paid every 2 weeks.
Okay. So pay period 16, what would be the corresponding dates related to that?
One moment, please. 19.
Yeah, so maybe you can tell me what pay period 19 would be.
19 would have been the 13th of September.
So that's the pay period ending September 13.
Yeah, that would be, yeah, the day I got paid was on the 13th. So I think the pay period probably would have ended that Sunday, September 8th,
Okay. So that's
because they would have the week of from the 9th to the 13th to do payroll,
process.
I believe.
Okay. So that's showing that withholding's occurring, at least going back, if September 8th is the most recent stub that you're showing, then we would go back 2 weeks to August 26th, roughly 25th, in 2 weeks. So sometime it looks like maybe in July, and there's payments in July, August, and September. Correct?
I would, yes, I would.
Because there's 4 payments, and that would
Yes.
wait to 2 months roughly.
I believe that would be accurate.
Okay.
I believe I started working for the post office in July.
Okay. Guys,
I don't have it.
Go ahead.
I apologize. I don't have a day exactly that I started. When I started with the post office, the application date is actually my starting date, but my days worked didn't start the day that I got hired onto the post office.
Okay.
So I'm not exactly sure.
So Ms. Geis, as far as the child support, it looks like there's been withholding. Have you received any child support from Division of Child Support?
I have received the child support. The issue that I've been having is he's had 5 jobs since January, and per the child support order, he's supposed to report those jobs. He doesn't, so he falls weeks to not months behind. That's why he's over 4,000 behind at this point.
Mm-hmm. Okay, and I think this is where I led off when we were talking about the purge amount for I showed that there was about $3,952 of back child support that was owed, and then we were talking about
that now at this point, though.
Right.
So
we were talking about a purge amount. So we're trying to calculate if you were to pay, looks like he's paid 362 plus 414 plus 432 and 461, which would be reduced from that original amount. Of course, this is based on the date, the amount of the pleadings. Yeah. So I think we would reduce that 3952 by those 4 payments, and that would give us the amount that would be the purge amount, which would allow Mr. Geis to purge the contempt if he pays the remainder of that amount.
Okay, what's the remaining amount?
So let me ask my friendly calculator here to make sure I do this correctly, and I'll speak it out loud so you can all follow along. So I have 3,952, and I'm subtracting from 3,952, subtracting from that the first payment of $362, subtract 414, subtract 432, subtract 461 is a purge amount of $2,283. So any questions on that calculation, Mr. Geis?
No questions on the calculation.
Okay. So I'll include here on this order is said that the contempt was found on September 18th for failure to pay child support. And then I'll just state that the purge amount to purge the contempt is payment of $2,283.
Okay.
So
I'm curious to what's the comprehension of my ability to be able to pay that, and what time frame even, because I understand the perspective to the situation, but what's the end goal in this? So that way I don't get to see my kids and I'm in jail. Like, I don't understand. I don't have money.
So the purging a contempt comes into play. There's certain aspects. If a person has been found in contempt a certain number of times, then that can have an impact at a final parenting plan hearing as far as the amount of time that a parent has. It can have some negative impacts. So when a person purges a contempt, that purge goes away and is basically kind of off the records. It doesn't count against you when we have a final hearing. So that provides some incentive for people to purge the contempt because it erases that black mark, if you will.
I appreciate your explanation. And I just want to make sure that's understood that at this current time, I don't even have the ability to be able to see Ezekiel because there's currently still a restraining order in effect, because it was approved that there was a temporary restraining order because when I took him down to the river, apparently when I brought him back, he had heat exhaustion, which ruled for a restraining order, which it wasn't necessary. And I have multiple people's testimonies to me taking care of my child and everybody being aware of everything going on around us. And, you know, it's been several months at this point in time since I've had to see Ezekiel, and I just don't understand, you know, like I already don't get my children, and I don't have the money to be able to survive.
Your Honor, I have told him that the restraining order was dropped, and I've tried to reach out to him for visits. He refuses to communicate with me.
Okay.
I wanted to hear it from the courts, and I wanted to see proof that I was going to not get a restraining order charge because I showed up to her house.
Judge Basher told him the restraining order was dropped.
Was
I
that
did not.
Was that at the most recent hearing on September 18th? That's where the contempt
No,
hearing.
it was one previous to that.
Okay, September 11th. I was on the bench. September 18th. Let me look and see if there's.
Might have been the last one. We've been here a couple of times now over this. So I'm trying to keep up.
So usually with restraining orders, they will expire on their own terms. There'll be a termination date, and that'll expire on their own terms. So let me just look and see if I can find. And okay, and what's the 93? Thank you. Okay, so I'm looking at a July 10th order. It's it's an immediate restraining order and hearing notice filed on July 10th, and it restrains Mr. Geis, pardon me, and it protects, restrains him from having contact with Ezekiel. And there's some distance restrictions, and
Judge Basher said I didn't have the right motion, so he couldn't sign it, and I didn't know what to do at that point.
so that was a temporary order, and it set a date for July 31st.
Judge Basher says that there was no basis to extend the restraining order.
So on July 31st, that restraining order that was initially entered on July 10th indicated the following. Court responds, no basis to extend the restraining order. Court struck the matter. So by virtue of the order from July 10th itself, it expired on July 31st.
I appreciate that. I was unaware of the circumstances, and I would love to be able to be in my child's life.
Okay.
I've been offering him visits. The one issue is he works weekends and he won't share his schedule with me to get a visit during the week.
I have most Wednesdays.
Oh, hold on one second. Oh, I apologize. It looks like our recording system had a hiccup, so we just need to restart the recording system. Sorry. Going back to the purge, I just want to share with you what I wrote as far as the order. It says contempt was found on September 18, 2024 for failure of respondent to pay child support. To purge the contempt, respondent shall pay $2,283. So I signed off on that. Issues related to communication and the parenting plan, those are not docketed for today, so we're not going to explore those very much. It sounds like the parties are having difficulty communicating. You might consider utilizing a service. Our Family Wizard is one. It's an app. It's a third-party app that records all communications between parties. It allows for exchange of documents. It allows for exchange of a mutual calendar that promotes parties that are having difficulty communicating to communicate for the benefit of the child being able to spend time with both parents. So that's one option.
So I've offered this before and he can't afford it. So that's why we haven't been able to do it.
Okay.
The expression to the situation was that I was willing to participate in that, but then the other party told me that I had to pay for her part in it as well if I wanted to communicate with her on that basis.
No.
So it sounds like if you both chip in your respective amounts, that might be a good idea. And Ms. Geis is indicating that she's willing to pay her half if you pay your half.
I understand.
Okay, so I've signed off on those two orders related to the child support purge contempt amount, and then also related to the $100 a month payment obligation and the continuing, what we call it a pay or appear docket, Mr. Geis. And so if on November 4th, if you know you have paid and you filed proof of payment with the court prior to that date, then you wouldn't need to be here on the 4th. If you have not paid, then you'd need to be here on the 4th of November to explain why.
I understand.
All right, so that'll conclude the hearing for today. Ms. Geis, do you have any final items or clarifying questions?
No.
Mr. Geis, any clarifying questions or final items?
No, I feel like that I've said what I had to say.
Okay, thank you, Mr. Geis. That'll conclude the hearing.
Thank you.
The cause number. Looks like we have Mr. Chapman present in the courtroom. He's taking a seat.
Yes,
Welcome,
Madam
Mr. Chapman.
Harris.
And then I'll ask you if Brittany Chapman, if you're on the line.
Yes, I am.
Okay, Ms. Chapman is on the line. Welcome to you.
Hello.
Okay, so this is a motion brought by Ms. Chapman for contempt and also a motion for adequate cause to modify the parenting plan. So you probably both heard me talk earlier about notice and opportunity to be heard in an earlier case, if you're listening to that. So I'm looking at this declaration of service that was filed by Ms. Chapman. So the amended summons for the motion for adequate cause was served on the 15th of September upon Mr. Chapman.
Correct.
So generally, there needs to be 20 days from a summons being served until the person has to respond or appear. And we're premature on those 20 days.
He did respond. I'm just not sure if he was able to give the proof of service to you guys yet or not.
Sure. No, I recognize he has responded. I recognize that. But procedurally, I just wanted to point out that shortcoming. With any rule, any party can waive the requirement. You can say, I want to enforce the rule, or I'm okay, let's move forward with it. So, Mr. Chapman, what's your vantage point on service?
I also do want to put in my copy for a parenting plan, put forward towards that too.
Your proposed parenting plan?
Yeah.
Okay. Then let me ask Ms. Chapman on the motion for adequate. Okay, so let me just pull this up. I've got my notes here. On the service, one of the requirements is with service that a litigant can't be the one that's doing the service. It has to be a third party. And they can be related to the case, but it can't be one of the litigants. So when I looked at the declaration of service filed on the 26th of September, this was filed by Ms. Chapman. It indicates that it says, my name is Brittany Chapman. I am not a party to the case. I'm 18 years or older. So I'm just making sure, I'm assuming, Ms. Chapman, that that's you, not another Brittany Chapman.
No, that's me. And the people at the court clerk's office or whatever had told me I had to put my name in there anyways, even though I am a party to the case. And we did the personal service forms. I don't know if that makes a difference. It's what I've always done.
Yeah, so looking at the second page where it says, I declare under penalty of perjury that the statement on these forms are true, and it says signed in Woodland, September 15th, and it's signed Brittany Chapman. So what that tells me, and it may be a Scrivener's error, wrote in the wrong name, it says that on September 15th, Ms. Brittany Chapman served the parenting plan change, proposed parenting plan, information regarding parenting plan, declaration of Jocelyn, declaration of Brittany, and a notice hearing for today, that she personally gave those to Mr. Chapman. So under the way that document is presented, that violates that rule that a litigant cannot serve the other party. It has to be a third party.
Okay. I had no idea about that because they said it was fine.
Yeah.
Every time.
Yeah, and I'm not faulting anyone. I'm just kind of laying out what the rules are.
Yep.
And not all of us spend our days in court, so we don't know all of these things off the top of our heads. Understandable.
Now I know.
So so then the motion that is, the declaration talks about those particular motion, the parenting plan motion, the motion to modify the parenting plan, and the declaration supporting that. So that particular motion is not really primed and ready to go because there's not been proper service, meaning, and some people will fault the court for this. It's like, well, hey, we gave Mr. Chapman all the documents and you're just saying just because I did it, we can't move forward today. Yeah, that's what I'm saying. It's fidelity to the rule. So the rule says Ms. Chapman can't be the one that's serving the documents. It has to be somebody else. So that particular motion, we're not going forward with it today. That doesn't mean that it's dead in the water, but it's just for now, today, until there's proper service with a proper declaration of service, we would not be hearing that particular motion today.
Okay. Can I ask a quick question?
Please.
A couple years ago, I was the only one who served everything and it was never a problem, which I understand there's rules, but I just had no clue. And then he also personally served me his declaration or his response. So yeah.
Yeah, and I recognize that, and I apologize if that led you down the wrong path or led both parties down the wrong path, but that's the rule, and I'm going to enforce the rule.
Okay, so now what should we do? Just
yeah, it's a valid question. So there's the motion to modify the parenting plan. We can't hear that today. There needs to be proper service. So once there's proper service, then you could note it up for a hearing just as you did today. So there need to be service provided to Mr. Chapman by a third party, and then the declaration of service would need to be filed, and then a docket could be set where that motion could be heard, giving him sufficient time to respond and you to read and digest his information.
Okay, and one more question. Since it's in concerns of their safety and they go with him again before this would all happen, there's still nothing. We still have to wait.
So there's, on the kind of the substance of the motion and modifying the parenting plan, it's not properly before the court. The court can make some interim or emergency rulings related to safety. One of those concerns may be alcohol and driving, if that's a concern. Hopefully that's not an issue, but I can order that today, that Mr. Chapman not do that. And I'm sure he would abide by that between now and then.
Ordered that.
Yeah, so that issue, we on kind of an emergency basis, I can address that if that's the safety concern that you mentioned.
It is. It's a big one, and they are to the point where they try to refuse going because they're afraid. And he's already been court ordered before not to drink while he has them at all, and he is doing so again while driving. So they're scared.
Okay. All right. So then the other issue is the motion for contempt, which I'm taking a look there as far as the
I have not
declaration.
had time to do proof of service to the court yet.
Oh, could you repeat that?
I have not had yet time to prove or do my proof of service to the court yet. I have it. I just haven't got to turn that in.
Okay. All right. So let me hear from Mr. Chapman. We've talked a lot about a variety of things. As far as the motion to modify the parenting plan, that's not going forward today. There needs to be the proper service. Do you have any questions on that?
I do not.
On the motion for contempt, that's where we talked that there, it looks like there's, Ms. Chapman had indicated that there wasn't the declaration of service related to that. And I know that you filed some response to that.
Right.
So I don't know if the parties want to move forward with that today, the contempt issue, or want to wait until that service is proper. So I'll just hear from each of you, Mr. Chapman.
I'd like to do it all at once. That way we get everything all done and hopefully not to, keep on coming back and forth.
So let me ask you a clarifying question on that. So it sounds like Ms. Chapman is probably going to move forward with the motion to modify, and she's going to do the reservice. So we'll be back at a future time for that issue.
Right.
The contempt issue, that could be heard today if the parties waive the service requirements, or it could be heard on the same date in which we come back for the parenting plan motion. Do you have a preference? Because we could do the contempt today.
Yeah, we take care of the contempt today. That's fine.
Okay. Ms. Chapman, do you want to move forward on the contempt today?
Yes, I would like to, because it talks about the drinking and driving as well in there. So I would love to tackle something.
Okay. So then let's move forward with the motion for contempt. So Ms. Chapman, this is your motion for contempt. And what I see here, that there's 4 grounds. One is related to expenses for the children and school clothes. There's also an allegation for spousal support. There's an allegation regarding drinking and driving. And there's an allegation regarding missed visits on Wednesdays. And then there was a 5th, I guess, if you will, regarding the half of the pension or the 401k.
Yeah.
So I'll hear from you. Go ahead, please.
As far as the drinking and driving contempt goes, start at that one because it is the most important one to me on there. He was ordered in, I think, 2022 that he's not allowed to consume alcohol at the time of visits or 24 hours prior. And he's also not allowed to drive over 30 miles with the kids, to which he is doing all of those things.
Can I ask you a question on that? The 30-mile restriction, is that in a written order? I looked for that and I couldn't find it. Maybe you can guide me.
I think he did a bench, or is that what it would be? A bench order to that? Because it wasn't in the parenting plan. He had done it separately, I believe. Nelson.
Okay, so I see a bench order from February 2022 from Commissioner Nelson. That does not address a 30-mile radius. There's a parenting plan from June of 2022. I looked in that and I didn't see a 30-mile limitation.
I have the paper somewhere. I just don't know where.
I see the no drinking 24 hours before the time for visitation and during. And I just look over it again to see if there's a 30-mile limitation, because I may have missed it when I looked at it initially.
It's somewhere. If I knew what it was called that he did, I could help you. And if I had it out, I could help.
And you think it was in 2022?
I think so. Maybe 2021.
I'm just doing a good quick search into 2021.
May rings a bell for me, I think.
So there's lots of contempt orders. I'm just looking through those. Okay, I've looked through every order. Not to say my search is perfect, but I find no 30-mile limitation. So I just want to clarify that. If you have other information, Ms. Chapman, that can guide me to that 30-mile limitation, I'm happy to hear from you. Otherwise,
okay, I'm going to find the paper.
Okay, so go ahead and continue related to your concern related to drinking and driving.
My kids have both came to me crying within the last 2 weeks about how they're terrified to go because he's still drinking and driving. He's hiding alcohol in the cab of his truck in a cooler. My son went and looked because he always wondered what he was doing when they stopped, and he would drink something out of there. And given past situations, he was concerned. So he looked and found it like 20 to 30 beer bottles and cans. He says he's 12, so his counting is probably not right. And as well as finding them all over their house, hidden in boots and behind their scooters and all of those places. And that is my largest concern.
Is the indication from the children that they actually saw him drink alcohol in the vehicle or in the home?
Behind the vehicle on trips. He would get out, go to the cab and drink. And then they have seen him, yes, in the house drinking as well. And then hiding, what he is drinking, to which they are accustomed to because of when we were married still. So
does the 12-year-old, is he or she the oldest?
He's the oldest, yes.
Does he have a cell phone?
Yes.
Does it have a camera on it?
Yes. I told him, I said, well, I need pictures, buddy. And he's like, well, I don't want to get him in trouble. It's like, I just don't want to go. Like, okay.
Okay.
And this last time they came back, and Brody, our oldest, had told us that I looked everywhere that there was the beer hiding and it's all gone. I'm like, well, yeah, probably. But yes, he does have his phone and pictures available to him.
Okay. All right. Okay. Other grounds for your contempt. Do you want to address the school clothes, kids' expenses, spousal support, and the pension?
The school clothes and stuff he's required to pay half of, like reimburse me for half. He never has done so. School, like sports gear and stuff, the last thing he has paid for was half of basketball last year. And we've had numerous other sports like football that just was going to happen, and then soccer and multiple other things. And then the contempt for the spousal support. There was no end date set on that at our last contempt hearing. Judge Nelson had said the amount due is $500 every month, but if you pay $250, you can't be filed in contempt. If you're filed in contempt again on this exact matter, you'll have to go to jail because of the amount of contempt there is on it. And he states that he's paid all of the past due, which according to my calculations is not right. But again, there was no end date.
Okay.
Due to non-payment.
All right. And then the pension.
Pension and 401k, I have asked him at the time it got ordered for help obtaining that, and there's nothing. He will not provide me with anything. No.
Has there been what they call a quadro? It's a qualified domestic relations order, anything of that nature?
Is that what that's something you file with the place that holds that money, correct?
Right.
No, but I don't even know who holds. I don't know any of the information.
Okay. Okay. And then, so let me ask you about the kids' expenses, school clothes and the like. Did you send, I was looking for something in your pleadings that said, okay, I sent receipts on this day and they total X number of dollars. Please pay me half of that amount. Did you provide that?
I have provided that to him. Yes.
Did you provide
just not in my
no. pleadings?
No.
Okay. So
I was in a rush to get this all.
So how do I know what the dollar amount is and what the basis of the request for half of the payment is.
Understandable. I, again, was in a hurry to try to keep them in a safe situation. So that all of that kind of just wasn't my number one priority at the time, but I can submit that proof as well for the next hearing if I need to do that.
Okay. All right. Thank you. Anything else, Ms. Chapman, as far as your motion for contempt?
I just want my kids safe and him to understand I'm coming from a place of loving our children and their safety. And I never want him to have less time with them. I just want them to be safe so that neither one of us have less time with them.
Thank you, Ms. Chapman. All right, Mr. Chapman, do you want to address those issues on the contempt?
Yes, I do. Your Honor, I do drink on occasion. I would never put my kids in harm. I love my kids dearly. I mean, I will say that I do drink occasionally, but nothing to be in a, a life-threatening way of, my kids or anything like that. Occasionally, as in, if I go out to dinner, I might have a drink. I would not drink and drive with my kids at all.
In the parenting plan, was there any requirement for you to undergo any type of evaluation for substance use disorder?
I see she put that in there that she thinks that I need it. There's no reason that I think I need it at all. Substance abuse, I will provide a UA if she thinks that I need it. But I don't think I need to do it every single time. I can show her once and she can see that I am clean on substance, all that. That's fine with me.
Okay.
But
so I was looking at the parenting plan from 2022, which kind of forms the basis of the motion for contempt.
right.
On page 2, it says, Bryce Chapman has a long-term problem with drugs, alcohol, or other substances that gets in the way of the ability to parent. And then it said a limitation would be no drinking 24 hours before residential times or during the time with the kids, and that attend AA meetings twice a month for 6 months. And then, yeah, so there's no requirement for an evaluation.
No.
Okay. All right, go ahead. Keep going, Mr. Chapman. So,
oh,
yeah.
me?
Oh, pardon me, Mr.
Okay.
Mr. Chapman. Sorry.
The next one, I believe, was school clothes and all that. So she texts me and tells me I need this amount of money, for their school clothes. I don't get a receipt. I don't get to know what she's getting. I don't even have a word in what she gets to go buy. So if she goes out and buys $2,000 worth of clothes, how do I say I can't afford $1,000 of half of that, right? You know what I mean? She doesn't, I don't even have the option to say, hey, maybe $100 a kid or something like that. So she just shoots me with a price and expects me to pay it. I've bought clothes for the kids before and, gave them to the kids to bring home, a couple outfits, shoes, whatever. And so that being said, the way that it's all working, with her just to be able to hand me, she doesn't even hand me a receipt, but just expect me to pay half of what she says is the amount due. I have no proof of it.
Does she provide you like a listing of the clothes purchased and the dollar amount or a receipt or anything of that nature?
No purchase items at all. She'll make a list on a cart on an app or Amazon or Walmart or whatever, and this is what I'm going to buy. I need you to send me half. It's not even purchased yet. I have no idea.
Okay.
Same with
I can't purchase them until I have half.
Oh, Ms. Chapman, hold tight.
So,
each party will have time allotted to them, and if you want to reply, then I'll allow Mr. Chapman to finish, and then you can respond.
So in my documents, I put in there, and I was sending money on Cash App, and it was for soccer for my daughter. She just started playing, and so that is being paid halfway. But football, she expected me to pay half. My son ended up not playing. So then what? It's kind of like a back and forth thing. I need to know for sure that he's going to be playing if I'm paying for half of it. He didn't even get, she said that he went to gear pickup and got his gear and everything. Things started kind of rolling, but then he was done. He didn't play anymore. He didn't even have a practice or a game. So that, I'm paying for it. I'm getting half of what they're doing. My youngest daughter is not in anything as I know, and she doesn't give me the schedules. I have no idea. Last weekend when I had my kids, she was supposed to have a soccer game on that Saturday. We had future plans already. And then she tells me, Wednesday, oh, she has a game, by the way, on Saturday. Okay, well, I have no idea. I have no schedule. I have no proof. I don't even know that she started yet. So, communication wise too is a big thing. I mean, I have no idea when games are, when, you know, things are going on with my kids. I don't hear about it.
Okay. And then you submitted, it looks like you submitted some, as far as spousal support, you submitted documentation from, it looks like March of 23 to March of 24 that you'd been paying spousal support during that time frame?
Yes, I have. And I came here to the clerk's office and got the printed off of them. I have their sticky note written down. And the balances on it too. So it came with the balances and it totaled up to what I became my last payment of. So getting that from the clerk's office,
So what's the outstanding balance?
what's that?
Is there an outstanding balance or it's just a log or registry of the payments?
There was so it was, we got divorced, right here. I was $6,400. And it shows on here, this is what the clerk's office printed off for me, with Nelson and everything coming on, it totaled up to $6,400 and the dates. And then I went through mine and printed off every statement that I had that I gave her for that, spousal support, and it totaled up to $6,400. So.
And so your position is that you've paid that?
I paid that in full.
And so Ms. Chapman had indicated there was no end date on the spousal support, but you're saying there is an end date because there is $6,400.
Right.
So how do I know that there's an end date?
So there's a total amount due, and that was it.
And where does that date come from? What final decree? So let me take a quick look. I'm taking a look at that decree 49.
I think it was in one of the last contempts where he stated there was no end date.
So I'm looking at June 15, 2022, the decree of dissolution. It says $250 each month, start date March 5, 2022, end date March 5, 2023, payable the 5th of every month. And it says whether or not there's an end date as a matter of law, spousal support will end when either spouse dies or the spouse receiving support gets married or registers a new domestic partnership unless expressly stated below. And then it says other 1 year. So the 1 year in the March 2022, the March 2023 shows that there's an end date.
And then, Your Honor, she does have a relationship, and you know, they are supposedly, you know, getting married and doing all this. So it's
No, we are not.
Ms. Chapman, I'd ask you to refrain from interrupting.
I know, I'm sorry.
She puts in the orders too that the stepdad, or you know, who they call Milo dad over there at their household, he lives there 24/7 and takes care and helps with kids.
Okay.
He's also one that drops off and picks up and does stuff too.
Okay. All right. And then what's your position related to the 401k and the pension?
So those are pretty much, that was when I was in the union. I can see what I have in there if I have anything, but I doubt I've lost quite a bit in there. So I didn't get vested in the laborers union, so I can look into it, but I really don't think there's much in there.
So as of June 15, 2022, half of the 401k and half of your pension is due to Ms. Chapman. So there need to be an analysis of what the value was on that particular date, and then half would be transferred to her.
From those time periods?
Yep.
What was the time period?
The decree was entered on June 15, 2022.
And until when?
It says half on that date, whatever the value was on that date, June 15, 2022. Half of the pension, half of the 401ks needs to be transferred to Ms. Chapman.
Okay, so from the previous from there.
Yeah, on that date, whatever the value was on that date. Certainly from that time, there's probably the stock market has gone up, so your values are going to be greater. But as of 2022 is the time frame that the 50% is calculated.
Okay, yeah, I'll look into it, but.
Okay. Okay. Anything else on the motion for contempt?
Was that the last thing to?
That pension was the last item on my list.
Okay, yeah, that's it.
Okay. Ms. Chapman, you had a few things you wanted to say.
Yes, number one, I am not getting married ever again. Number two, her soccer game this last weekend was also an abrupt thing for us as well, because she had her staph infection on her leg and everything else, making it to where she couldn't go at all. So when I found out on, I think Thursday about her game, I let him know. I always let him know. And as far as paying for, he did end up not playing because he wants to focus on his grades because last year he struggled. So he chose not to play. So I never ended up continuing to ask for the half of payment of stuff because I didn't have to order it. And now I'm losing my train of thought. Oh, and the spousal support, it's $250 a month, but the amount due is technically $500. So he's only paid, according to me, like $3,500. So I don't know where we're getting the $6,400 from because he only paid $250 for a year.
Yeah, help me understand your position there, because we looked at that decree of dissolution that set the spousal support at $250 per month for a period of 1 year, and now but you're telling me that it's $500, and I'm not quite sure where the $500 per month comes from.
Because it was always $500, but he never paid for a whole year. So after I think 11 contempts being filed, or maybe just 7, I don't know. There was a lot. Judge Nelson had changed it and just said, okay, the amount total due is $500, but $250 is paid, then you can't be in contempt. But if he doesn't pay the full $500, then
contempt would be on the table.
Then they're still stacking the $250 every month that he's not paying from the $500, just adding up.
Okay.
Does that make sense?
Yeah, I think so. What you're telling me is that, yeah, $250 is the amount owed based on the order, and that there was arrearages or non-payment, and then there was a desire by Commissioner Nelson that those would be paid, so basically double the payment. So it would be that he could purge the contempt by making that $500 a month payment.
I don't know if he could purge it by doing that. I think the purge amount was $1,000 originally, and he paid that. But basically, they just cut his payment in half to where I couldn't file in contempt if he paid the $250. So, but if he paid the $500, great, because that's the amount due.
Let me ask you, it looks like Mr. Chapman filed some documents showing $250 payments in from March of 23 to, well, it looks like it started maybe November, let me go back here, March of 2023 to August of, well, December 23, there's a January 24 payment, there's a March 2024 payment. Did you see those documents that he filed where he's showing a payment of $250 to you?
Yes, and I'm aware I got those, but it's still not all the way, because if you 250 times 15 months, that's only 37. So it's still not paid. He still has the 250 on top of that was not paid every month of those that is still due.
So help me understand this. The decree says 12 months at $250. So if you have 12 months times 250, that's $3,000.
Yes.
And
he even said his outstanding balance was $6,400.
Repeat that for me again.
And he also states his outstanding balance was $6,400, which is correct, but that's still only $3,000 paid. And again, in one of the contempt papers, it states somewhere that the amount total due is $500. Can't file contempt if he pays the minimum of $250.
Okay.
And now am I making sense, or am I really confusing you?
No, it makes, I mean, it's a little unclear, but it makes sense what you're saying. It makes sense. Let me just, there's one other question I was going to ask.
Oh, I have one more comment before I lose it. Where he says how he would never drink and drive with the kids. There's very much proof from the last time he was caught up with that he will drink and drive with the kids. My car was full of alcohol where my kids were at that morning. So to say he never will is hard, because he does in fact do that, and my children aren't lying to me.
Okay. Thank you, Ms. Chapman. The clerk pointed me to a document. I'm just going to take a look at it. It's a February 1, 2023 order on contempt. Okay. All right. Thank you. Anything else, Ms. Chapman?
I don't think so. I really don't think so. I don't want to do any of this. That's what I do know.
Okay.
But I have to for my kids, and I have to be their advocate. Unfortunately, because here I am.
Okay. Thank you. All right, so let me just go ahead and give you my ruling on the contempt. There's a contention that Mr. Chapman is drinking during the time that he's parenting and also while he has the children in the car, and he's drank or he's drinking while driving. And that's supported by statements from the 12-year-old who said that he saw, 20, 30 bottles in a cooler, finds bottles hid around the house. And the one instance where they say that they saw him drinking was during a trip someplace, so he went around the corner and drank something.
My 9-year-old as well.
So so in order to prove a contempt, there needs to be what we call a preponderance of the evidence, meaning 51% versus 49% or 50.1 versus 49.9%. That proposition has been proven by that level. Here, obviously, the allegation is very concerning. Nobody wants their children ever to be exposed to somebody who's been drinking and driving. It's absolutely unsafe. It's unwarranted. And a lot of people I know that drink and feel that they're safe drinking a beer and driving. They may be, they may not be. You don't really know until you're in the moment of panic when you have to take evasive action. And for anybody to drive or to drink and then drive, whether with children or without children, is wholly irresponsible. So I can't emphasize that enough. People die because people drink and drive, and nobody wants any harm to come to these beautiful children. Nobody wants harm to these children. And a lot of times I think people overcompensate when they drink, or they think I'm fine. And obviously if they've been drinking, their ability to think clearly is compromised. Here, there's just not enough evidence. I think there's some valid concerns that Ms. Chapman has, but I think there's just not enough evidence there. And with the prior finding of alcohol issue or substance use disorder by Mr. Chapman, if there's anything that you can do to make changes, I would encourage you to do that, because the court can order you to do X, Y, and Z, but there's nothing that will bring a child back if you make a fatal error.
Right.
So I'll make a finding of non-contempt there. As far as the school close, what I look for with the school close, I have to base my decision on what's basically written, what's provided to the court. So if dollars are spent on clothing, there needs to be receipts. There needs to be an itemized list that's sent to the other party, and they need to pay half. I haven't seen that, unfortunately, so I'll deny that motion for contempt. The spousal support, I think, is a little more clear. I know that there's been a lot of motions related to this. The divorce decree says $250 per month for 12 months. So that's $3,000. So there needs to be a payment of $3,000. Mr. Chapman has provided proof that he provided $3,000 worth of payment, so I'll deny that contempt. The 401k and the pension is a different story. I'll find contempt there. Nothing's been transferred since 2022, so I'll make a finding of contempt. Mr. Chapman needs to talk to the people who coordinate or run the 401k or the pension and get a quadro drawn up, a qualified domestic relations order, and make sure that as of the date of that dissolution decree, that 50% of the value of the 401k and the pension is transferred to Ms. Chapman. You can purge that contempt by making payment of the 50% of the 401k and 50% of the pension. Otherwise, so I think we need to set a review on that. I want to make sure that's lingered far too long. So I'm going to set a review. Quadros do take time. So I'm going to set a review for second week of January 13th, 2025 at 1 p.m. So does that date? January 13th at 1 p.m. Does that date work for both parties, Mr. Chapman?
You said January, right?
January.
Okay.
Okay. And Ms. Chapman, does that date work for you?
Yes, it does.
Right. January 13th, 2025, we'll review the payment of the half of the value of the pension and the 401k. So I'll make a finding of contempt. I think there's been prior contempt findings, so I'm required to impose a $200 civil penalty. And so I'll impose that. So that's the court's ruling. Does any party have any clarifying questions?
I do.
Go ahead, Ms. Chapman.
So since these things of the drinking and driving has already happened, and now he is well aware to not let it be known again, and keep it hidden from them, how is my son supposed to take pictures? And also,
I don't, yeah, I apologize if I suggested that your child be placed in the middle of all this. There's the drinking and driving. I think if there's concerns related to that, then you could bring a motion for, because I didn't see anything in the parenting plan that allows one party to request a UA. So you could bring a motion to ask Mr. Chapman to take a urinalysis, and you'd have to take that within 4 hours. and it would be loser pays. So you would front the cost, you would pay for it, and then he takes it. If it comes back that it's clean, that there's no alcohol, then he would have to you would just eat that cost. If it comes back that there's alcohol present, then he would need to repay you. That's a motion that if you bring that motion, we could entertain that motion, and that may provide, at least on your perspective, additional safety for the children.
Okay, it's so hard because they don't know to get the proof, and I knew it would be hearsay even if it's from them.
No, and
But
I
it's
don't want to
hard.
put the children. I don't want to put the children in that position.
Me neither.
Okay, any other questions
Yeah, Your Honor. So did you say that there's a $200 penalty on top of that
for the finding of contempt? Correct.
for
The pension and the 401k.
Okay, when does that just go on top of that payment goes through, or when is that
It's payable in 30 days.
payable in 30 days?
Any other clarifying questions?
That's it.
Okay, Ms. Chapman, any other questions?
I don't think so. I just am reserving him and doing the other proof of service, correct? Okay.
If you'd like to do that, yes, there needs to be proper service.
Yes, something has to be done.
And then if you want to file a motion related to the UA provision, then that's something that you could make motion
Okay.
in your order or your request. Okay, I think we completed things for today.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
All right, looks like both parties are present. You're Ashley Pino. Okay, and then you're Francisco Gonzalez.
Yes, Your Honor.
Okay, great. I'm just going to pause just for a quick second to finalize that last order on that last case, so it's still fresh in my mind. So just if you'll bear with me just one moment, please.
Mr. Stevens, this is the court clerk. It appears you may be in the wrong courtroom. Your matter was in a different courtroom at 9 a.m. I can give you the dates that were set today if you'd like.
Yes, that would be fantastic. I was self-represented today, and this was the only docket for self-represented.
You
at
you were supposed to be on the universal trial assignment docket.
Is there? I was not given any information. Just that I had a Zoom court date today. So maybe in the future, is there anything that could be done to direct people on where to go?
I don't have an answer for that. Let me just share with you the dates that were set today.
Okay. Yes, ma'am.
Your readiness date is February 4th, 2025 at 11:30. And that will be on the readiness docket, universal readiness.
Okay.
If it's still on Zoom at that point, you will look for the universal readiness docket. And your trial is currently set for the week of February 10th, 2025. You will be given they'll clarify that date at your readiness hearing.
But that was February
10th
at
8:45. But like I said, you'll get an exact start time at your readiness hearing.
Okay, and the readiness hearing, I just go on cowlitcounty.us to see if it's a Zoom or in person.
And it'll be, you'd look for universal readiness.
Okay.
You can call the week before and see if it's in person or via Zoom.
What was today's court hearing about?
Setting those dates.
Just setting those dates.
That's
All right.
all it was.
Thank you very much.
Trial assignment.
I apologize to the clerk for the confusion. Thank you.
So we're here. Let me get the case pulled up again, just a moment. Okay, so we're here with Ms. Pino and Mr. Gonzalez. Just so you know, I called your case right at the top of the docket, about 9:03, 9:05. You weren't there, and I said, we'll wait and we'll call it at the end of the docket. That's why you're at the end of the docket. I called it first, and so I apologize. I didn't get to you earlier. So let me just, as far as the case, this is a motion brought by Ms. Pino for temporary orders related to a parenting plan and the home and the like. What I see is that I always check for service issues. I always make sure that the moving party always needs to provide the documents to the other party and provide a proof that they've served the other party. And there's some timeframes that relate to that. There has to be 21 days prior to the date of service, in between the date of service and the date of the hearing. So what I see is that Ms. Pino did properly serve Mr. Gonzalez with the documents related to today's case. And that was served on September 18th. Today's October 2nd. That's shy of 21 days. So there's a local rule. If you go to the Cowlitz County Superior Court website and you'll see a blue box that says rules. You can click on that and then look for local rules, look for rule number 88. 88 is really key for family law matters. And there it specifies the timeframes that need to be followed in these types of cases. So we're here prematurely because that 21 days has not transpired. So according to my count from September 18th till now, that puts us at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, about 14 days. So we're about a month early. And that's why I called a week early, sorry. And that's why I called your case earlier, because I wanted to say, hey, we're here prematurely. We can't hear the substance of the motion. And I apologize, you had to wait 2 hours and 40 minutes to hear that news. And I also saw that Mr. Gonzalez had filed a motion for a continuance. So that's kind of where we're at. And I just wanted to inform you both of that we're here prematurely. The service is fine. It looked like the service was fine.
Yeah.
But we need to take a look at setting this to a different date that meets those timelines. So I'll hear from the parties as far as the time, when to come back to hear the matter. Ms. Pino, you're the moving party, so I'll hear from you first as what you think would be appropriate time for him to come back to hear the motion.
Well, currently I'm a soccer coach and my son starts basketball soon.
Mhm.
We have open gym tonight, so I'm hoping, and also I'm a college student and I work as a CNA. So busy schedule.
Sure.
I'm thinking if we continue, isn't court usually on Wednesdays?
Yeah, it will be during the month of October.
Okay.
Come November, it'll be on Mondays at 1.
Okay, so would the 23rd or the 30th be okay?
Okay. I'm fine with either of those dates. Mr. Gonzalez?
Yeah, that
23rd.
works. And in her defense, I work out of town a lot, so I should have let her know a little bit sooner that I was in town.
Will that work for you, the 23rd?
Yeah, that'd be
Okay.
Okay. All right. So we'll set over the Ms. Pino's motions to the 23rd of October. And then I saw that you both had submitted proposed parenting plans, so I've reviewed that. And then if there's additional information that you want to supply, if you look at that Court Rule 88, that'll give you guidelines of the number of declarations that you can supply and the length of each. So just take a look at that and be familiar with that. Again, that's where you go to the Cowlitz County Superior Court website, click on rules, a little blue box, and then click on look for rule number 88.
Yeah,
Okay.
with their legal aid.
Okay.
Legal aid was one that advised me to kind of go this route.
Okay. So it's premature, just by about 7 days. So we'll be back there's no criticism intended to anybody. There's just that's the rule. So we'll be back on the 23rd of October at 9 o'clock in the morning.
Yes, sir.
Okay. See everybody then. Thanks.
Thank you. So, am I allowed to see my daughter?
Yeah, you can see her, just message me. We'll figure it out. Of course. That's all you need.
Yes, yeah, that's the last matter I had on the docket. So that's the last matter on the docket. So go ahead and end the Zoom call. Thanks, everybody.